Oh my goodness, I thought we were going to have a quiet night, but I was wrong. Elise is back. You guys remember Elise? Good old Elise? Elise Dorsy, who failed in her claims and got countersued and has to pay the man she accused. Well, she's back and she's there. I guess the reason they're basing this on, it's insane. I don't want to spend a lot of time. My throat's kind of a little raw. I've been talking nonstop several nights in a row and recording something else, and my throat's just about had it. So I don't want to take a whole lot of time, but this is crazy. It's absolutely crazy. So I think some of you just came from Lauren's live, and I didn't get a chance to listen because I was prepping my own, but I'm assuming most of you came from there, and so you already know the contents of this. So ACC, your heart's still pumping from Lauren's live. Yeah, I don't blame you. I was so mad. But never fear. You know, they huff and they puff like the big bad wolf, but that's about it. They really missed the mark again for a lot of reasons, and that's mainly what I want to point out. So I'm not going to go through and read the whole document. And if you haven't already watched Lauren's, you can go to hers and watch her go through that. I'm going to go watch hers after I finish mine, in fact. Yes, Nikki, it's just a big word salad. That's what it is. And I'm surprised they had time to come up with this tonight, with tomorrow having so many. They've got 3 depositions tomorrow. One of them being Van Zandt, and one of them being this guy that they had the big fight over. They're starting bright and early, 8 a.m., very early. And you'd think that they'd just be getting ready with that instead. But alas, here we are, as we often are. So this is in support of the motion for attorney's fees, treble damages, and punitive damages under California Civil Code, Section 47.1. They're going to fight with all their might to keep 47.1 in, because I really honestly think they really want these fees. I think they really need these fees because these attorneys have billed the heck out of these people. And I'm so glad they have, because it couldn't happen to better people. But I think they did it on the promise that they were going to get these treble damages and that it was going to cover everything. The first thing that we're going to look at is this table of authorities. And I don't know if you guys are familiar with this, but what this is all of the cases that they're going to cite throughout the brief or document, whatever it is. So this is the first thing I looked at, because what I keep saying, and I know some people don't like that I say this, and they're like, well, that's not so. And I'm like, well, then find a case and prove me wrong. New York does not like to apply other state law. Now, everybody is supposed to, if that's the chosen choice of law. So they're never going to outright say we don't do that. But if you look not at the cases that they take and say they apply it, I'm talking about the prevailing cases where that choice of law is used for somebody to win, whether it's summary judgment or especially given to a jury to apply that state's law. So, hi, Christina. If you don't have time to do this, it's okay. It's a more informal one. I can watch the chat. I know I gave you no heads up again. I'm so sorry. I'm the worst. But you guys, Christina's so amazing. She really is. But yeah, if you're cooking and stuff, don't worry. I'll watch the chat. What I'm talking about is a case where they actually say this case, they take this all the way to the jury and say, jury, you're to follow California law. Here's your instructions. It just doesn't really happen. They will apply it when they plan to dismiss it. They've got, and he did in this case with Wayfarer's claims. He says, I applied California law. To me, that's just lip service if you're dismissing it. I'm talking about where they hand it to the jury and say, follow this state's law. That's what I cannot find. Or where in summary judgment, another state's law is used as choice of law and they actually prevail. They don't lose. That is a unicorn. Look at this table of authorities. What do you notice? It's California, California, California over and over and over again. Do you know what that tells me immediately? Because if you are trying to prove your case, and in this case, what they are trying to prove, this is Ezra's document, she's trying to prove that California law applies here. Now, if you're trying to do that, does it not make sense that you would try to find New York laws? Find New York laws that have upheld California choice of law and say, see, they did it here and they did it here and they did it here and they did it here, and that's why I'm right. This is what you do. You choose case law that supports your side. The whole argument of this entire document is that California law applies here. What we should be looking at here is case after case after case, like Ellen did, that's in the Southern District of New York that applied California law. That is missing. So as soon as you look at this table of authorities, you know there's a problem. So that's the first thing to keep in mind. Even the statutes that they use are this. But their authorities, starting with that table of authority and all the way through, they're just not strong. So we're going to go ahead into the introduction. And here's the claim that they keep making through this, is that, well, they chose California law and now they want to revoke it. Well, they can't do that. Well, listen, lady, they filed this case, first of all, in California, and they filed a case against New York Times. They filed a case against Leslie Sloan and Blake. It wasn't just one person, and it started off as a lawsuit in California. They did not come to New York and say, hey, New York, we want to file this lawsuit here. They had a case in California. But what happened is the whole thing got consolidated, because when you have a case like this, they don't want the same case being ruled on in different places. They want it all consistent, so it all gets removed to one place. That's what happened here. So saying this, first of all, is factually incorrect. They had a California lawsuit and they got moved to New York. And they probably wish that they had never done it in the first place, now that they've seen how it's gone for them there. But accepting California law, knowing that the California law your opponent wants to apply against you isn't going to hold up, like knowing that in advance and choosing California law is not, that's a brilliant move. So if they said, yeah, we'll take California law because they plan to, they foresaw that, hey, this isn't going to hold up under California law, that's a brilliant move. That's not saying, yeah, we're gung-ho California law and then finding out, uh-oh, there's a problem. Oh, no, we don't want California law. That's not what happened. Yes, they accepted California law, but in the back of their minds thinking, this isn't going to apply in the end, so the joke's going to be on her. So she has really distorted the facts of the case here. That's not what happened. We know from early on that Brian Friedman said there's problems in their case, but we're not filing a motions to dismiss because we don't want them to realize it. Because if they had done it back then, she could have amended it. She could have changed it. To say that this is what happened is a misrepresentation about how this went. So that's a fail too. So then her next claim in the next paragraph, if you saw, we went over that Nowhere Pennington, and that it extends, that it started off as antitrust, it started off as lobbying, but I showed you the case laws from, I think in that one I showed you Ellen's, plus I found more. Yeah, I used a Supreme Court case to back up Ellen's argument. But they're saying the Second Circuit has not decided whether this even extends to non-commercial litigation. This argument that they're using here goes against them too, because what else has the Second Circuit not decided? It has not decided how to use 47.1. Your argument works against you as well. So here's yet another fail. But also, as I said, I showed a U.S. Supreme Court case that applied that and showed that it goes beyond the antitrust. This is not correct either. So says the Supreme Court. Okay, and Yeah, so as far as this argument that the Second Circuit hasn't decided, you know what else the Second Circuit has never done? They've never applied an anti-SLAPP. They've never applied 47.1. And you can say 47.1 differs from anti-SLAPP. We don't have any court's rulings on that. We have nothing to go on with how 47.1 gets applied. Okay, so then she goes on to say that none of Wayfarer party's case law addresses application of a state's law when the party resisting application itself brought claims under that state's law. That has nothing to do with whether or not a federal court in New York is going to apply 47.1. You know what else she never once mentions? But unless I missed it, all of the constitutional issues that were brought up. Why is she not mentioning any of that? That was a big deal. They need to combat that. And I'm not seeing that here. She's picking out stupid little things to argue that really don't make a lot of sense. Okay, this is another claim they keep saying, that the only relevant conduct is the retaliatory defamation action, and that failed. That's all she needs to justify the application. Then Wayfarer had said that you can't apply 47.1 without factual findings, that Miss Lively acted without malice and had a reasonable basis to make her complaints about harassment and retaliation. Where did that come from? Did Wayfarer just make that up? Wayfarer cited that because that's what the actual law says. If the actual law says without malice, that means you have to prove that there was no malice. That's not something Wayfarer made up. That's written in the law itself. We heard when it was going through, if you saw, I did a video about the passage of 47.1, and I found every video I could possibly find when it was just a bill being presented to be passed to a law. Every one of those videos. And we saw that addressed. Someone asked the question, and they specifically said that this was the fail-safe in the law to make sure that people weren't falsely accused. This reasonable basis and this malice. It's written in the law. Wayfarer saying it was, like I said, it's not just something that they made up themselves. It has to be proven. So what they need to be doing here is not just saying, no, she doesn't. No, she doesn't. You're wrong. No, she doesn't. I'm sorry. That's not a legal defense. What you need to be doing is showing that your client did not do so with malice. That's what you have to do to get this law to work. It's written in the law. The law itself says it. That's what you have to do. So instead of saying, nuh-uh, 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 show that Blake did this without malice. There is nothing in here to support that their client did not do this without malice. What else is written in the law? This reasonable basis. Where's the support that your client made this complaint with a reasonable basis? You can't just say, nuh-uh. You have to prove that. Does that make sense? Do you understand what I'm saying? Sometimes I just ramble because I've got the thought secure in my head, but I'm not like executing the thought well. These two things are written in the law. These two things must be addressed, whether you like it or not. And that's what you have to prove to get this law to work. The Wayfarer parties argue that the court cannot conclude that Miss Lively is the prevailing defendant in the defamation action, which has now been dismissed with prejudice or abandoned in its entirety. Nobody argued that their cases were dropped. Nobody argued that. What they argued was that she still has factual issues that she has to make. That's what they said. It's a different argument altogether. So they argue Miss Lively must endure a jury trial to prove that she already prevailed. They didn't say exclusively a jury. They said a trier of fact. A trier of fact is most often a jury, but it can also be the judge, but not at this phase, at the summary judgment phase. Why does it have to be the summary judgment phase and not motion to dismiss and not this motion that they just filed? It's based on the pleadings. Because to prove these things, you need evidence. So that's what they need to step on it and start doing. Start proving that there was no malice. Start proving that it was a reasonable basis. Without those two things, 47.1 cannot be applied. It's really that simple. And then this earliest stage, they keep saying this. We're not going to jump into that right now. We're going to get there in a second. But that's where Elise comes in. Look at this in pink. They go, this is wrong. Miss Lively's claims do not necessitate Miss Lively to prove that she acted without malice. Have they read 47.1? It says it. It outright says it. Like, how can you say this is wrong, that it doesn't necessitate something that the law absolutely requires? It's crazy to me. Then they talked about the damages, and they said, how do we calculate damages when no damages have been presented to the court? And their answer to this is so dumb too. She says, oh, not so. Miss Lively has already requested a schedule to introduce evidence of her actual damages, which will be established by the close of expert discovery on November 14th, 2025, and which the court can then treble. Okay, but you're asking the judge to rule now. How is he going to rule now, but you don't even have the damages presented to the court yet? Nobody's seen them. Right now, they're just a figment of imagination. That you have to wait and get these experts. And I'm just wondering what kind of experts, because the only damages that she can't do emotional distress, because she withdrew those. Those were 10 and 11, and she withdrew them because she did not want to prove through medical records. She can't bring that back. So how is she going to prove damages to her career or to her hair care line? You can bring any expert that you want. You cannot prove missed wages when she never worked regularly. If you had a regular 9-to-5 full-time job and something happened to you because of this type of event and you couldn't work that job anymore, you have real damages to present to the court. She didn't. She hit and miss worked little jobs. And she's advertised that she's got movies in the works. She cannot prove she has any damages in that regard. Her hair care, if that can even be brought in, because this job was an actress job. It wasn't a hair care salesperson job. So how's she going to bring that in? And the emotional damages, forget it. You withdrew those. So what in the world is she going to present to the court? And the whole fact is, she hasn't presented them yet. So how is she going to ask the court to do that now? He needs all of that information because he has to make a whole sheet of it. He has to decide how much to give her in damages. He can't do it without the damages, but they're demanding he do it now. So fail, Ezra. Okay. Should not be permitted to avoid the consequences of their retaliatory litigation tactics any longer. The court can and should rule on Miss Lively's motion at this juncture. See, they're asking her now. Fees and damages, that's where we were. But I feel like there was something else I wanted to say. Oh, yes. This was the other thing, this retaliatory litigation. Okay. And they keep saying that this law was written specifically for cases like this. Let's talk about why that's not so. So some situations, like the women who came to the hearings where this was a bill trying to be passed into a law, they told their stories. And the stories were where a woman had something like this happen at work, and then she was fired, or some really serious workplace retaliation, like legit workplace retaliation happened. They usually lost their job. And then filed the lawsuit and then got a retaliatory defamation case right back at them. But what happened in this case? Is that what happened? It's not what happened. So, I mean, not even to get into the point that she claims she made a complaint in May of 2023, but then it's August 2024 when people start talking bad about her on the internet, and then good old Stephanie Jones supplies her with these illegally or ill-gotten messages, and then she's mad that people are talking about her, and she's like, oh, okay, talking bad about her, and then she's like, oh, okay, that explains it. People don't hate me. It's Wayfarer's fault. And then she does all of this. But this lawsuit that Wayfarer, first of all, it wasn't just Justin and Jamie. It wasn't just the men accused of this. It was the entire group of these people, most of which, the majority of which in this lawsuit were not accused of SH. But they are, in fact, part of this lawsuit. They didn't just sue Blake. They sued Ryan. They sued the New York Times. They sued Leslie. They sued Stephanie. This was not. So when you're talking about a retaliatory defamation claim, you're talking about one woman suing one man and that man suing her back. That is not what happened. A newspaper article came out in the New York Times with an accompanying video, and it was horrible. It had terrible accusations in it, not just against the person that Blake claimed SH'd her. It had text messages of Melissa Nathans. It had text messages of Jennifer Abels. So it was a group of people suing another group of people about a defamation that was put in a newspaper. This is not, by the slightest, the biggest stretch of imagination you could possibly imagine, this is not a retaliatory defamation case. This is you put that out there and said horrible things about all of us, and we don't think you should get away with it. So calling it a retaliatory defamation case that's eligible for 47.1 is such a mistake in the first place. Did you accuse Jennifer Abel of SH? Did you accuse Melissa Nathan of SH? Did you accuse? Do you know what I'm saying? For it to be a legit retaliatory defamation case, that's what it would have to be. The people that you accused of SH file this against you for saying that you committed SH. But that's not what it was. It was because you ran to the newspaper and you said all of these things. And Stephanie Jones supplied you with these things. And Leslie Sloan threatened this lawsuit months before it came out. So it doesn't even qualify as what they're calling it. It's such a mess. Okay. And then here we go with this again. Well, if they didn't want to face the consequences of California law, then they shouldn't have invoked it. If they invoked it, knowing that 47.1 was not going to hold, that was just brilliant. Just because they were fine using California law doesn't mean that they said, oh, okay, you can use 47.1 against us. They accepted it, believing it wasn't going to be able to be used. So that's not the gotcha that you think it is. And again, where's your proof that your client made this claim without malice? Where's your proof that she made it with a reasonable basis? You haven't even tried. Where's your explanation of how this doesn't trample all over the Constitution? Because they listed multiple amendments to the Constitution that this tramples on, and you've said nothing about it. And then they bring this up, oh, if you're going to chill petitioning 47.1 if you don't recognize this, and then all these retaliatory defamation suits, blah, blah, blah. And then they bring up the one exception to the Noah Pennington is sham exception. And they're like, well, this is a sham because his defamation claim didn't hold up. It doesn't make it a sham. And you know what? Chicken butt. No, the judge never said it was a sham. He said that her declaration was protected activity, and and so that the defamation wouldn't hold up. He didn't say it was a sham. And then she talks about the numerous exceptions, and look what they are: perjury, false report of a criminal offense, discipline of attorneys who engage in solicitation. In other words, it's not really that easy to overcome. It requires criminal activity. The only criminal activity that's taken place here was done by Stephanie Jones, Blake Lively, and Ryan Reynolds, allegedly. So don't make it like it's that easy, and then you bring up the instances and they're all crimes. And then this drives me crazy. California legislature's intent to carve out an exception to the litigation privilege to deter retaliatory defamation actions based on reports of sexual harassment and retaliation. Where are you getting this definition? Are you taking something from the California legislator as proof, or are you just self-describing here what you think their intent was? Where are your quotes from the many times that it came, like I said, as a bill to be passed as a law? There's lots of conversation about those. I don't see any of that quoted here. Where are you getting, other than your own definition, that that's what they intended? If you are going to say that that's what the California legislator intended, you better have a quote to back it up. Otherwise, it's just you saying that. Thank you, Lo. We all know Blake Lively is planning her victory tour on shows along with her crappy image office. Oh, yeah. And a ridiculous jewelry that looks like it came out of a bubblegum machine. Okay. And again, they got to keep bringing up these Thorowitz and Friedman out-of-court statements. Just like she said about the first motion, that it was just this whole long list. I called it a list of whiny complaints. It was never focused on what it needs to focus on to make 47.1 happen. And here we go again, bringing up this stuff that has absolutely nothing to do with the requirements for invoking 47.1. It's again, she's doing it again. Just whiny complaints. Talk shows. Thanks, Flo. I didn't quite get what that was. Talk shows. Okay. Thank you so much. Okay, then let me see. And then we get to the next page, and where does Elise come up? I know. She's undeniably the prevailing defendant. That doesn't mean she met malice or reasonable basis. Okay, here we go. This is where they're trying to prove that this case was brought to New York. It says intentionally brought the suit to New York. No, they didn't. They filed the case in California. It got brought to New York when it was consolidated. So stop saying that it's not true. And it says for their own benefit, and now argue here, what is this, the third time she said this? Now they argue that California should not apply to them in the same litigation. They didn't say that California law should not apply. They said that the things that cannot be applied outside of the jurisdiction of California cannot apply. That's a completely different argument. Some of the claims can, but the ones that cannot go extraterritorially, no matter how bad you want them to. So this, again, a misrepresentation. And then to try to support it, look what she says here in pink. The Ninth Circuit is over there in California, and it has absolutely nothing to do with what's happening in New York. They don't have the same rules. We're talking about the Second Circuit. But look it, there's not a single case law that supports what she's saying that's from the Second Circuit or from the Southern District of New York. So I didn't even bother with these because you know why? None of them apply. California, Ninth Circuit. Doesn't matter. Doesn't matter what they do in the Ninth Circuit. Guess what else they recognize in the Ninth Circuit? They recognize anti-SLAPP. Second Circuit doesn't. There are a lot of things like that that, yeah, they may apply in the Ninth Circuit. They don't apply in the Second Circuit. So none of this matters. These whole 2 pages, waste of paper. Okay, then we move into, I keep saying it, she is unquestionably the prevailing defendant. That wasn't their argument. Never once did they say Blake didn't win the defamation lawsuit. Never once did they say that. This is not up for argument. Everybody knows she prevailed in that. That's not what they argued. They argued it's unconstitutional, and they argued that she has to prove malice, and she has to that she made it without malice, and that there was a reasonable basis. Okay, now we get to Elise. So here we have this quote again. So they say it again. The California legislator made clear that Section 47.1 remedies must be made available at the earliest stage to prevent protracted litigation that would re-victimize complainants. And then this is her authority. Okay, docket number 24, I forgot to put it up here. Page 17. Do you know what document that is? I'm just going to read it. It's from Elise Dorsey's Amicus brief. Do you remember who Elise Dorsey is? She is the woman who began an affair with her professor, her married professor, married with children, young children at the time, professor. If it ended there and she filed a harassment suit, I would be all in support of her, because it was an authority figure and a young impressionable. Right? My favorite lady. I can't believe she actually admitted she would have gotten damages if not for discovery, and that is her problem with it. So you remember, okay, if it had ended there, I would support this woman, because I would say you were young, you were stupid, you were a student, that was your teacher, that's an authority figure relationship. But the affair continued for 11 years. She married, yes, Rose is wild, Elsie's a psychopath. She married in the meantime. She was married. Okay, she graduated from law school. By the time you finish college and law school, you are full grown. Your brain is developed. You've got no more excuses. You can't claim you're too young to know better. Your brain's still developing. You make poor decisions. You go off and get married. Now you are married, and this affair continues. And you've known all along he was married and had little kids. What else goes on? She knows that he's had multiple mistresses and not just her. And when she wants a job, where does she go? She runs straight to him, because he's very well connected. He helps her get job after job after job. She sometimes works with him at a job. And all along, this affair keeps going. And then 11 years later, he decides that he wants to end his marriage and marry one of his newer mistresses. Not only does he end his marriage for this mistress, and this mistress is someone that she knew, someone that Elise knew. She knew there was a fellow mistress. Like, the whole thing is so bizarre and disgusting. So she knows this woman, but now he's like, okay, she's going to be my one and only, and I'm ditching my wife and all my other mistresses, including Elise. So Elise gets dumped for this other mistress. Elise is married, but it breaks her heart. She can't take it. She fights with him, publicly fights with him. She sends him angry emails. She's so devastated by him breaking up with her that she's angry, and that's when she files her sexual harassment lawsuit. Is that sexual harassment? I mean, these people went on trips together. It's Van Johnson says Elyse Dorsy, mistress of the dog. That is exactly what she is. That is exactly what she is. And she was mad because she got dumped. She would probably still be carrying on that affair to this day if he had not dumped her. They're escapees from swingers. Yeah. And so she's got this harassment claim going on. Well, he countersues. He's like, heck no, this isn't what happened. Well, guess what he's got? He's got witnesses to the angry fights that she had when he broke up with her. He's got angry emails. He's got all the receipts in the world to show that this was an ongoing affair and everything was fine until he ended it. This woman was well in her 30s by then. But by all means, let's put her, not only her amicus brief is on this docket that the judge clearly said he didn't read or consider in his decisions, but let's refer, out of all the amicus briefs on file, let's refer to Elise's amicus brief as the authority to prove that the California legislator meant that 47.1 should be applied at the motion to dismiss stage. Does that make any sense to you at all? This woman is not an authority on anything. I would not take this woman's advice on anything in my life. I wouldn't hire an attorney like her. And they cite her, of all people, her amicus brief as proof of what the California state legislator had in mind with this case. It's insanity. Badly done, Ezra. Thank you again, Glow. It says, I hope Ellen brings that up in her response. I hope she does too. Please, Ellen, please do. Elise pretended that she never wanted him at all, and he was creeping on her and made no mention of consenting to it at any point. Yes, to any of it at any point. She did. And yet worked with him and ran straight to him, and he had all the proof of it, of her coming to him for help getting jobs. I bet the judge read that and said, oh no, there's no way I'm invoking this mess. Hers was the first one to hit the docket too. It was the first one. It probably is. It's probably the reason he probably read hers and he's like, no way, I'm not touching any of these. And no, that amicus brief did not help her. It made them both look nuts and weaponizing 47.1 with lies and BS. Exactly. If I had been counsel for Blake, I would have looked at that brief and said, do not put that on the docket. But instead, it was the first one. And now it's the very one she quotes from. It's insanity. Yeah. Mary says Blake's lawyers are trying to lose the case by doing this. Yeah, I said a long time ago to her, I think that was the title of one of my videos was, do Blake's attorneys hate her? Because some of the choices they make are just absolutely insane. Yeah, her version of events sounded insane. It really did. It was absolute. What's that Sharon Stone, that old Sharon Stone movie where she goes nuts? Because I can't remember, but I think you guys know what I'm talking about. But that's what it was. It was just, she just lost it. Okay. And this one in purple, like, some of the statements they make, I just cannot believe it. Whether Miss Lively acted without malice to make her complaints is not a necessary element of her affirmative claims. Where do you get that from? When the law itself says that, how can you boldly make this statement in your legal filing? Are you really that stupid? Basic instinct, that is. She's a bunny boiler. Yeah. Yes, she is. She's trying to twist the meaning of prevailing, just so manipulative and deceptive. Because the law does say a prevailing plaintiff. It does say that, but that's not all it says. It also says malice, and it also says reasonable basis, and they just want to skip completely over that. Dr. Royster says she's so distressed she's at Disney World. I saw that on on Instagram. Yeah, and I was like, oh, she's there because she wasn't invited to Selena's wedding. So she went to Disney World. But yeah, I cannot believe the things that they need to be proving. Like, they make these ridiculous statements, but the whole point of this motion is supposed to prove their case, and they're not proving anything. So prove that it doesn't trample over constitutional rights. There's nothing in here. You see, we're at the conclusion now. Not one word about the Constitution. Prove that your client, instead of arguing that she doesn't have to prove that she didn't do this with malice, prove that she didn't do it with malice. Instead of arguing that you don't have to prove she made the complaint with a reasonable basis, prove your client made it with a reasonable basis. And instead of using Elyse Dorsy to prove what the California legislator had in mind when they wrote this law, quote from the California legislature, I can't even speak. Where is your legal proof? If you want to prove that New York applies California law, use New York cases, not California cases. Of course, California cases apply California law. Show the New York cases that do. So this whole document is nonsense. It's proof of nothing. Yeah, the law is written procedurally vague. Everything about that law just makes me mad. And there is no application for anybody to rely on for how it's supposed to be applied. So everything that Elyse Dorsy is claiming is how it's to be applied means absolutely nothing. She is not the authority on this law. There is no authority to refer to say this is how this law is supposed to be applied. But none of these arguments have successfully refuted the arguments that Wayfarer presented, that my darling Ellen presented in her motion. Waste of paper, waste of ink, waste of time. And if Judge Lyman rules any of this in her favor, I will be so mad. Just like that last one where he would not hear from Ellen, but he took statements exclusively made by Michael Gottlieb that were incorrect, and he ruled on that, and then he had to pull it back and reconsider it about Case and Coslow. Remember that? Because he, instead of looking up the law and instead of doing the research to see what he himself had decided in a hearing and what he had decided in a motion to dismiss, if he had looked at that stuff, which is what he's supposed to be looking at, he wouldn't have made that mistake. But instead, he took Michael Gottlieb's word for it, and then he ended up making a fool of himself and having to respond to a motion to reconsider and change his order. That's where we're at. The judge doesn't look at what he himself has said in the past in a hearing or what he himself ruled in a motion to dismiss. He listens to Mike Gottlieb, and Mike Gottlieb's stuff was wrong. And so now the judge has this on the docket that he messed up and had to reconsider it and rule a different way. I'm so sick of this stuff, and I'm so sick of him being defended. I do not want to hear this judge defended. Something is very, very wrong here. I gave him the benefit of the doubt at first, even after I had talked about his financial conflicts of interest, including the article that was written up that exposed that in his not even 2 years being a judge, there were 13 cases that when they investigated him, they themselves found there were 13 cases that he should have recused himself from and did not. He wasn't even a judge for 2 years and had already done that. And we have every reason to say this judge does not go by the book. This judge has issues. But even after I talked about the things that I had a problem with, I still, in his rulings, and I'm on record saying it, I don't like it, but I can see where it's legally sound. Leanne and I together, I specifically remember the two of us saying, because we were all mad about a ruling, but we're like, We have to say it's legally sound. I'm not to that point. I don't defend this man at all anymore because something is not right here. When he ruled that way for Michael Gottlieb, when he has sat there and lawyered for Blake and brought up arguments that her attorneys didn't even bring up in a hearing, and he was there doing it for them, that's not his job there. He's the referee. He's not there to help one of the teams. Or when he's sitting there telling an attorney, you can do attorney's fees, you could file for attorney's fees. They know they can. Why are you telling them that? That's you taking a side right there on paper for the world to see. It's disgusting. What did you do? What did you do now, Kenny? Kenny is so outspoken. I love her. Her little daily post to Ryan Reynolds and Blake Lively on X. I sent her an email one time on Instagram and said, I hope they get you. And she said that I have no idea what I'm talking about, and she's deposed all the time. It's fun. Who did you do that to? Kenny, such a fighter. And then she blocked you. Who? I want to know. Okay. What's wrong here is Judge Louis Jeffrey Lyman is silently working uncredited for Manette. It feels like it, I've got to say. Wait, what am I doing? Yeah, it does feel like he's part of the team because it's, and some people have said, well, he's doing his best to make sure that Blake, he knows she doesn't have a good case, and so when she loses, she can't come back and file an appeal. Then why does he have so much like absolute hatred towards every member of the Wayfarer team? First, I thought it was just Brian Friedman, but Brian Friedman stepped back and he's like, okay, I honestly, I don't know that he did this, but I just feel like he did, because I think, if I were someone representing a client and I felt like the judge hated me, this is what I would do. I would step back and say, I'm not going to let the judge's feelings about me affect my client. So I'm going to step back and you guys move forward. So then Kevin steps up, and Kevin is so brilliant. I love his writing. Absolutely love his writing. I think we all fell in love with him when he started writing his motions. But then the judge started hating him. And then they're like, okay, well, let's send Ellen. Who could hate Ellen? And he's mean to her. And so that's it. It wasn't ever about Brian Friedman. But he's never treated a single member of Blake's team the way he's treated the entire Wayfarer team. Never. So, you didn't. Oh, you thought it was Elsie? Yeah, I heard a bunch of people reached out to her after Lauren and I exposed her. Right after the Amicus briefs came out, I found the story, and Lauren and I went live and told her story, and then everybody started contacting her on on X and stuff, and she started blocking everybody and turning off comments and stuff. It was bad. But here she's back as the authority on what the California legislature had in mind. So I kind of reused a thumbnail because I didn't want to take a whole lot of time tonight to make a whole new one, but I felt like it still applied, that this is what she did. She got mad when he chose a different mistress than her, even though she was married. Like, why are you mad? You're married, lady, in case you missed that. But yeah, it's insane. You can, I should put a link in comments to that live that Lauren and I did. If you missed it, you can go back and watch it and see the true story, the full story, because the full story about his counter lawsuit against her, it's behind a paywall. It's a magazine an online magazine for people in the legal field that you have to pay for. So it's not easy to get to. So it might be one of the only places that you can see it. So I'm going to link that if I remember after I log off. So if you didn't see it, you can go see it. But anyway, sorry, my mouth is dry, my throat is raw. This probably sounds awful. But anyway, thanks for joining again. And yeah, like I said, I thought it was going to be a quiet evening. I'm working on another story. One of my friends, she's married to one of the top attorneys in the whole Murdaugh case, Mark Tinsley, absolute brilliant attorney in South Carolina. She's married to him, and she has started a podcast that is so good. And I think there are 4 episodes. The 5th one is about to drop, but I interviewed her, and she's doing a really good story about a man in Memphis. There are so many problems in Memphis. But I helped her with a little bit of, she did like 99.9% of the stuff, but I helped her do a little bitty section of her research. And so I've been so excited waiting for it to finally hit. And so, yeah, I recorded an interview with her, and so I'm working on that, and so I'll hopefully have that out for you in a couple of days. But yeah, I thought I was just gonna chill, work on that, and have a quiet evening. And then I saw that filing, and I was like, no. But thanks for joining, and I don't know. We'll see what tomorrow brings. If I see you tomorrow or not. Have a good night, everybody.